So, in the today's episode of Income Tax Decoded, we'll be talking about the most debated procedural puzzle that have been there in the recent tax administration of India. We will be talking about the reassessment notices tug of war between the jurisdictional assessing officer and faceless assessing officer. The big question over here is who exactly has the authority to issue the reassessment notices under Section 148? So, whether it is jurisdictional assessing officer or the faceless assessing officer. From the time the government of India have introduced the faceless assessment scheme, the main idea behind the scheme was to make the tax administration more transparent, automated, and free from the physical interference. And lakhs of reassessment notices continue to be issued physically by the JAO, but later on transferred to the faceless assessment system. So इसमें क्या हुआ कि lakhs of reassessment notices जो थी वो physically ही JAO देता रहा and it was later on transferred to the faceless system. But this is where the procedural chaos begins and it is where the whole debate starts. So, in the Telangana High Court case of Dipanjan Roy, the court held that as per CBDT notification dated 29th March 2022, only faceless assessing officers are empowered to issue the reassessment notices under Section 148. And as per the Clause 3, subsection B of the scheme, it is crystal clear that automated allocation, faceless functioning applies even to the reassessments. And the High Court made a very strong observation. High Court ने एक very strong observation दी that if jurisdictional assessing officer issues such notices, it directly defeats the purpose of the faceless system. तो फेसलेस सिस्टम इसीलिए लाया गया था कि ये जो जुरिस्डिक्शनल ऑफिसर या फिर जो फिजिकल टच था वो सब हटाया जाए एंड डायरेक्टली सब फेसलेस सिस्टम के थ्रू ही सब हो एंड इफ द जीएओ कंटिन्यूज टू गिव द फिजिकल नोटिसेस इट डायरेक्टली डिफीट्स द पर्पस ऑफ व्हाई द फेसलेस सिस्टम वाज ब्रॉट इन द फर्स्ट प्लेस एंड इसके अगेंस्ट इनकम टैक्स डिपार्टमेंट जो अपना रेवेन्यू है उसने चैलेंज किया इन द सुप्रीम कोर्ट बट द सुप्रीम कोर्ट डिसमिस दिस एसएलपी दैट इज स्पेशल लीव पिटीशन उन्होंने डिसमिस कर दी सुप्रीम कोर्ट ने. And the point to remember over here is that a dismissal of SLP is not binding precedent under Article 141 of the Constitution. So ये dismissal majorly इसलिए हुआ था कि सुप्रीम कोर्ट के इस बेंच में कोई भी मेजर सीनियर काउंसिल था ही नहीं and that's why Supreme Court dismissed this SLP. But the main interesting thing over here is that more than 700 similar matters currently pending before another bench of the Supreme Court. मतलब दूसरी एक बेंच के थ्रू भी ये ऐसे ही similar 700 केसेस चल रहे हैं and it involves the major cases of Surya Lakshmi cotton mills and it also includes the hexawire. So the final verdict of this bench will ultimately determine that can JAOs issues reassessment notices in the post faceless regime or not. And whatever and if the Supreme Court decides that JAOs cannot issue such notices, that is jurisdictional officer cannot issue such notices, over 1 lakh reassessment notices could be nullified. So अगर सुप्रीम कोर्ट ने ऐसा बोल दिया कि jurisdictional assessing officer is not empowered to issue such notices, over 1 lakh reassessment notices could be nullified and would become void. And this isn't just a matter of interpretation. It's about how the reassessments will be administered in the faceless era moving forward in the next decades. So I would be very curiously following this matter. And if there is any another update that would be there, I would be there with it. And to get more such tax insights and updates and over 10 lakh plus judgments, kindly visit councilwise.com. And to get the full order of the High Court and the Supreme Court in this case, kindly visit the description box and do click on the link given in the description box. Thank you.